Now, I'm attributing no personal fault to you, Ms. Modise, but what I'm going to be putting to you is what is stated here is not entirely accurate. So let's just look at it. Subsequent to the letter from the House Chairperson, the committee issued a report documenting its past oversight activities over the Department of Transport and PRASA during the period 2014 to 2017. Let's just pause there. This request is made in the middle of 2017. The report detailed engagements regarding the management and operations of the entity, which also included various references to investigations into financial misconduct alleged within the entity, and then the sentence that I take issue with. Specifically, the committee submitted this report in lieu of a formal inquiry and did not generate any new insights. In other words, the suggestion that's made in your submission is that the response from the Transport Committee is, we've done all that, there's no need for it, we've investigated adequately thus far. Now, let's just leave that there. I won't ask you a question about it because I want to put something else to you. If I take you now to page 736 of the same bundle.
Presented.
736. Well, perhaps that's not fair. I think it is fair. You have it. It's a letter dated the 16th of March 2018. So the impression created by your joint submission is that really there was the response of the Transport Committee is that there's no need for an investigation because of our prior oversight. But if you read this letter of the 16th of March 2018, I want to put to you that it shows that that can't possibly be correct. Not least because if you go to page 738, second paragraph, you will see in its meeting of 20 February 2018, the committee resolved to institute an investigation into the matters of concerns regarding the various stakeholders, etc. And then they talk about, in the second last paragraph, the terms of reference having been adopted. This committee actually did resolve, but only resolved in February and March of 2018 to carry out an investigation of precisely the sort that was directed by Chairperson Froelich. And what's more, I want to just explain to you, we have had evidence from both Mr. De Freitas, Mr. correct, the DA member, Manny De Freitas, of attempts that he made in this committee to have these investigations take place. And we've had Ms. Magadzi, who has responded, and I think she herself accepted in her evidence that the committee had been remiss in failing to investigate as they should have. So all I want to really put to you is, can you accept that when your joint submission says that really there was, from the response from the committee, no need for an investigation and it died there, your evidence is just mistaken because there's a whole lot of detail which you were presumably unaware of?
Chair, I have no option but to accept what you are saying. But remember that we also said in our joint submission, and I noticed that this letter that says now we are investigating comes from the same member, Magadzi.
Yes, indeed.
Who you are telling me had earlier on said that they were remiss in not investigating. The chairperson of the NCOP and I stated up front that where we have not personally dealt with matters, we have been informed that things are right and we accept that they are right and true because we could not
that I understand the spirit in which this evidence is given. You were not even then the speaker, much less personally involved, but you are now the speaker. You rely on documents that have been presented to you. You've made clear in your submission that not everything is in your personal knowledge. You rely on documents which are attached. But nonetheless, it's my duty, if I see something that seems to be wrong in the document, to point that out. Otherwise, what you've said might be taken as being clearly correct when there's reason to suspect that it may not be correct.
Chairperson, I'm grateful that the disconnect is pointed out to us.
Yes.
That means we must be more thorough next time.
Yeah. No, that's fine.
Now, I want to just move on and deal quite briefly with a few other features of your joint submission. So, can I take you to paragraph 54, which is at page 21.
I have it.
Now, I just want to put this in context. Quite understandably, what your joint submission does, after referring to the Frolic letter and the press release that we've looked at, you look at the 4 committees that were identified by him, but then you move on and say that it's also important for the Commission to be aware of things that happened in other committees beyond those 4. And one of those that you draw attention to is the Portfolio Committee on Police. And you make the point in paragraph 54, during the 5th Parliament, the Portfolio Committee on Police, in addition to its business, held 6 meetings on state capture. These meetings considered progress reports by the Directorate of Priority Crime Investigation, DPCI, on high-profile cases under investigation, including state capture. And you then itemize those in the paragraphs that follow. You refer to what happened on the 28th of February 2018, the 7th of March 2018, and so forth, through to March of 2019. And I have no reason to doubt that those summaries are reasonable summaries. But the point I want to put to you is, again, this has to be seen in context, does it not? Because this is commencing once the new president has taken office, and it is not showing us what this committee, the police committee, were doing in the heat of the era in which these allegations were being made. And I want to put to you, for example, just to illustrate the problem, that there has been a lot of evidence before this commission in relation to Bosasa. In relation to Bosasa, the evidence is that in 2010 or perhaps 2011, the SIU had investigated these allegations. It was publicly made clear that these allegations had been reported, that a report had been given to the National Prosecuting Authority, perhaps referred for further investigation. 8, 9, 10 years later, we are not seeing precisely the sort of response that you are highlighting here as to what happened from February 2018 onwards. We see precisely the opposite. That although this report is in the public, not in the public domain, but although the members of Parliament are fully aware that the SIU believes there is substance in these very serious allegations of extensive corruption, nobody is saying, what's happened to this prosecution, or if they are, not with any diligence or follow-through. Do you want to comment on that at all?
It's difficult to get into the head of something that happened in 2010 and try and make an intelligence response. I can't even tell you what I was doing in 2010, whether I had heard of this or not. But I will go back to my response that perhaps we need to make better use of the legacy reports from portfolio committees to carry on. Because between 2010, you have an election in 2014, I'm not even sure whether the membership of the committee is still the same. But what we do have being constant is the administration. And that is why I went on earlier on to say perhaps that's where we need to make the link. So that as you have the new membership, the new committee chair, there is orientation and there is a discussion about the resuscitation of business. Because if you have a new committee and nobody brings to their attention that there are, by the way, there are issues that were hanging there, they will continue and discover new things. And if the executive or the administrative heads are still the same, who says they would be keen to reopen what they perhaps don't want to reopen?
Yes.
So we can only charge ourselves as Parliament to say we need to be more alert to this. We need to pay more attention to the last reports of committees and the revival of committee work reports.
Yes, but you know, I accept your point, but your point illustrates the problem of what happened in fact rather than what should have happened in theory. Because the legacy report in 2009 raised this as a matter of extreme concern. The SIU report is issued shortly into the period of the next portfolio committee. When it issues its legacy report in 2014, not even mentioned. But notwithstanding that, it remains reported on in the press, and nothing happens. Now, I suppose this is really not a fair question to put to you because you're not directly involved in this. But the principle we can discuss. And the principle is that I'm sure you would accept that it is incumbent on responsible members of Parliament within their respective portfolios, when serious allegations of corruption have been made known to them, and when it's been reported to them that the SIU thinks there's merit in these allegations, to satisfy itself by repeated questioning and follow-up that these allegations have been appropriately disposed of. You would accept that principle?
I will accept that principle.
One would obviously not want to dictate to Parliament how it should deal with its internal matters, but it may well be that the House Chairperson responsible for portfolio committees should make it his business or her business if the gender changes. Make it his or her business to know the legacy reports of the various portfolio committees, particularly what was identified as needing further attention by the incoming committee, but that also once the new committee has identified, has looked at the legacy report and identified matters that they want to take forward, which came from the previous Parliament, that maybe they should share that information with him or her. So there would be somebody who has a globular picture of what's taken. But that might just be something. It may be that it's not necessary, but one would think somebody who coordinates some of these things, and maybe if something is left out, is not pursued, that seems quite important, then ask questions to say, but this is important, why are you not taking it further? I don't know what do you think that might help?
It will help. We have been looking at the capacity of Parliament, and that seems to me it falls right there, because if you can't retain not only the bad, also the good practices, because as you empower members, you must be able to pull out the good examples and the bad examples. And so for me, it comes back into how do you ensure that things don't fall between the cracks. So In that regard, I would not even say that leave the blame with the chair of committees. Take it right up to us who are responsible. Speaker, do something about that. Make sure that you track, you know where things are. And that is a commitment I can make, Chair.
Thank you.
Thank you. If I could now take you to page 16, please.
16.
16. This is when you, after having introduced the topic of what are the duties, what is oversight, what is accountability, you start dealing with the substance of your submission. And you make the point in paragraph 32. You say the Portfolio Committee on Justice and Correctional Services raised its concern about the delay in establishing the terms of reference for the Commission. That is this very Commission before which you are now testifying. Now, I just want to pause and consider this a little. Because in October of 2016, the Public Protector released her State of Capture report. There was some initial controversy about whether it was going to be made public. There was some threatened or actual litigation. But by November of 2016, as your supplementary submission correctly points out, it was in the hands of the Speaker of the National Assembly, and if I'm not mistaken, I think it may well even have been tabled before the National Assembly. Is that correct so far?
Yes, it is correct.
Now, the recommendation by the Public Protector that there should be a Judicial Commission of Inquiry whilst it has its advantages, and we are seeing many of the advantages now, it also could perhaps have been used as a pretext by some not to do what they should have done. So there was a view that was expressed by some that this question, all these allegations, should simply be left from the time of the October 2016 State of Capture report through the whole of 2017 into 2018. It's not Parliament's business. Let the Commission be appointed. Now, from what I've been hearing in your evidence this morning, you would not be of that school. You would be of the school that Parliament must do Parliament's job. And if Parliament is aware of allegations of relevance, they have the power and should exercise the power to investigate, obviously seeking not necessarily to duplicate in two forums work being done simultaneously in both. But the principle that the existence of the recommendation for a judicial inquiry is not a good reason for Parliament not to do its own work. Do you agree with that principle?
I agree that within the powers and responsibilities of Parliament, any matter could have been investigated. If the Judicial Commission was then established, then all the committees would have needed to do is to hand over the work that they had done so that there is no duplication.
Yes, and I don't think that anybody here takes any issue with that. But what you then say in paragraph 32, and I'm not saying it's wrong, you say the Portfolio Committee on Justice and Correctional Services raised its concern about the delay in establishing the terms of reference for the Commission. But that was one of the issues on which, in my request for further information, I said when. You answered that in your supplementary submission, and we find the nub of the answer at page 412. This is one of the additional documents that you furnished. And it exactly bears out what you said. But of course, as ever, timing is important. And we see that this is a report dated the 24th of January 2018. is after the election of a new African National Congress president. This is a whole new political world we're in. Parliament's Portfolio Committee on Justice and Correctional Services today expressed its grave concerns about the delay in releasing the terms of reference with regard to the Commission of Inquiry into State Capture. Committee Chairperson Dr. Matoli Machecha said that the President must issue the terms of reference as a matter of urgency, and it must be based on the remedial action of the Public Protector's report on the state of capture. This matter cannot be delayed any further. Now, I don't think anybody would criticize Dr. Machecha for saying that. But my question to you is whether you think that the pending possibility of this commission of inquiry actually served as an excuse that was latched onto by some for not doing what they should have done in Parliament in relation to the issues, very serious issues, that emerged from the Public Protector's State of Capture report.
Chair, I'm not sure how to answer this question. I have to now creep into people's minds and try and explain why. Remember, Chair, that Parliament does not have the powers to establish a judicial commission.
Yes.
They can just make noise and urge the President to do that.
Yeah, you can put pressure.
They can put pressure on the President to please hurry up and do this thing. In the meantime, as I said earlier on, nothing would deter a committee to do the little bit that they can.
Yes. And the only part of your answer I take issue with is the word little bit. Because those committees have a power of subpoena, they have a power to compel people to come and answer questions, and they have expertise in their own respective domains. So in fact, it's a significant power that they have.
They have big powers. I used to boast about those powers. But the little bit I'm talking about is that at that time, most of the information that is now in the public domain and within the reach of Parliament was not there. That most of the issues which we are now confronting, and sometimes we still get shocked. There was the hearing on the Intelligence Committee, and we sat and held on to our chairs because there are things that the rest of committees would not know, and therefore the little I refer to is what I know and what is before my committee I must pursue, so that each and every committee can then, and that is why Mr. Frolik was right in writing to those committees that were identifiable as being affected by the state being captured, to say, hey, hurry up and investigate.
Yes.
Because in that way, he thought, we as Parliament, that perhaps we would be able to get to understand exactly what has happened, what is the extent of this thing. Up to that time, we had never heard of a member of Parliament who had received any money relating to doing or not doing their job.
But what you had heard long before that time, this is what I explored with Mr. Montashe last week. As early as February of 2011, reports in the press alleging undue influence by the Gupta family, not only over the President, but over the appointment of cabinet ministers, over the appointment of SOE boards and chairs. And Mr. Montashe's response was, well, we had no evidence to confirm that. But then in an NEC meeting in that very year, a minister says, well, I can confirm it. I was one of the people who was told by the Guptas, and nothing happens. Now, with the benefit of hindsight, and this is obviously not a matter of your personal accountability, we're looking at the system. With the benefit of hindsight, would you accept that Parliament could and should have investigated a lot more vigorously, a lot earlier?
Chair, I'm on record as saying Parliament must investigate any matter related to their portfolios as portfolios. It is difficult sometimes when you investigate everything that you read about in the newspapers. Because I have read stories about myself starting to read, and only when I saw my name I then became aware, oh, they're talking about me. Information that I didn't know, things I'm supposed to know or have done that I do not know. So when you get into that space, you realize that Parliament, and that is why when a member stands up in the House and makes an allegation that is serious, that can affect the standing, the conduct of the member, we immediately say substantiate, so that we actually deal with facts. Now, if a member of the ANC sits in the NEC of the ANC and says, yes, the Guptas, how does Parliament transport that into a portfolio committee?
Well, that was going to be my question to you, because either it can or it can't, but I think the answer must be it can. So if the allegation is that there is undue influence affecting ultimately the control of state-owned entities, then that seems at face value to fall within the remit of the Portfolio Committee on Public Enterprises. And how can they deal with that? They can summon that very minister, and they can summon the persons whom he accuses, and they can examine whether there's any truth or not in it. Do you agree with that?
I have to agree.
I guess that is,
But-
Mr. Freund,
but-
if they get to know
If they
what
get to
happened
know.
in the NEC.
Oh, absolutely.
Yeah.
Absolutely. But what was alleged to have happened in the NEC was also reported in the press in that year. Now, they wouldn't know if those press reports are true, but at least it gives you the basis to ask the people about whom the press reports have been made, did you say that? If so, please tell us the details. If somebody else denies it, come and tell us your story and we investigate. That's really the problem, that for year after year after year, these allegations that I as a citizen, who had nothing to do with Parliament or politics, I was fully aware of, it seems to me Parliament turned a blind eye to and just did not investigate. Now, I don't know if you wish to comment on that.
Yeah, it is difficult to comment on this, because the question I put is, how do you take a discussion which happens at a political party into Parliament? Supposing they had done it, Chairperson, would that committee, particular committee, not have been accused of taking factional issues of the ANC into Parliament and therefore? So sometimes you need to put yourself into the political space and try and understand where were they coming from. If the minister had made that statement in a portfolio committee, in the House, definitely we would have had to say, but this. It's difficult with hindsight to say, but they were wrong here. Is it a matter they could have investigated? Yes, they can investigate anything, anytime. Why didn't they do it at that time? I really don't know.
Yeah.
Now, I understand that you were not party to that. You were not in that committee. It was not a decision that you personally had to deal with. But I'm trying to explore the question of principle here. And the question of principle really is this. If there are allegations in the public domain, not only in the press, well, I mean, they're made in the press, but they are reporting matters which, if true, are a very considerable concern, that I'm sure you would agree those should be investigated. So the question then becomes, well, was there sufficient material in the public domain to justify an investigation? And Mr. Mantashe told us last week that by 2013, the Integrity Committee of the African National Congress was urging the President to stand down in relation to these very sorts of issues. If it was known to them, surely it was known to enough people in the ANC that if the President didn't step down, if the President disputed these allegations, which was absolutely his right, there was a duty to inquire through Parliament. I emphasize, through Parliament, not merely through the structures of the ANC, whether these allegations of state capture are true.
My thing would be that the ANC, knowing, getting evidence and perhaps even proof, should have dealt with their internal problem, should have acted rather than to say, we will sit back and see if Parliament can take this matter. Because that for me is not really shouldering what is your responsibility. If Mr. Mantashe said that they knew as early as 2013, then they should have done something about it in their collective leadership, so that today we do not hammer members of Parliament who do not sit in that NEC, who may not have heard at first hand what the Minister Mbalula had said at that time. When you will remember, Chair, that there was a time when I was accused of having written a document and given it to Patricia de Ligt on the arms deal. It was out there. It was not investigated by Parliament. It really wreaked havoc with my personal life. When the Mayor de Ligt came out in the open and said, it is not that one, but I have given my undertaking not to reveal the names of these people. There was no investigation. I asked for it. So I can understand that the frustration is something is being said there, and sometimes somebody is being wrongly accused there. Why are you not investigating? At the end of it, I was told, no, we understand you didn't say it. But the damage out there in the street was something else. And I had to wait until that man who had given the document, whatever it is, to Mayor de Ligt, died for Mayor de Ligt to feel free to say, in fact, so-and-so had given me this document. And it was years later. So sometimes not getting, and I couldn't get anything of substance that I could go to the police and say, investigate this, other than to start a fight with my own party. Because the accusations were not coming from Parliament, they were coming from the party. So sometimes you look at circumstances and you know that if the committee perhaps has even tried to probe quietly and they don't get substance, they're going to be unable to run with this thing.
I think that you and Mr. Freund might not be on the same page, or it might look like that, but maybe you are on the same page. Let me ask one or two questions to see if we can clarify this. My understanding of your evidence includes that you have no problem with the proposition that members of Parliament, obviously chairs of portfolio committees and members of portfolio committees, different portfolio committees, ought to keep themselves informed of what's in the public domain in case part of what is in the public domain it relates to their work in the various committees and may well require them to do something in order to carry out their functions. Am I correct so far?
You are correct, yes.
Yes. Another point that I think you may be making is that obviously you can't expect members of Parliament and members of various committees to investigate everything that they see in the media. Is that correct so far?
You are correct, yes.
What I think you then suggest is that when members of various committees or members of parliament see certain things or become aware of certain things that are in the media that fall within their portfolio committees, they need to weigh them up. And if they are serious enough, they need to take steps using their powers and the rules of parliament and the mechanisms in parliament to do what they need to do. Is that correct?
That is correct, Chair.
Yes. And therefore, I would say that I would understand you to say the mere fact that Mr. Mbalula may have said what he said at an NEC meeting doesn't on its own prevent members of parliament, if they become aware of it, from weighing it up and seeing whether they should take certain steps. Is that correct? That is correct. Yes. So it just depends whether it has come to their attention and whether when they assess it, they think it deserves further attention.
It does, Chair.
Yes.
Alternatively, if they take what is unproven into a committee, they are within their rights to approach any of the state agencies that are responsible. They could have approached the police to say, look, there is this thing. We can't handle it. We don't have evidence. Can you look into this matter? That would have been, the way to go.
Yeah, but also, excuse me. But also, my thinking is that there would be nothing wrong in a member of a portfolio committee or a member of parliament in the National Assembly, but a member of a portfolio committee who has become aware of what was said in the NEC to actually put a question to Mr. Mbalula, who was a member of parliament, who was a minister, put a question intended to see whether he will tell the committee the same information that he told the NEC. And if he tells the same information, then you take it from there.
I would agree. Alternatively, to even put such a question to the president himself.
Yes, to the president himself, Thank you. I hope that has
helped. Yes, thank you. And Ms. Modise, I don't disagree with you that there will be many situations in which it would be the sensible course of conduct to ask, for example, the police to investigate. But there are also situations in which the powers of the portfolio committee are not limited to asking somebody else to investigate, and they're not restrained in only calling before them the executive. They can call before them anybody, can't they? They can call before them, for example, the Gupta brothers.
They can call for documents.
And it's a question of judgment as to whether there is allegations or information available that make it responsible and appropriate to ask those questions. It all depends on the prevailing circumstances. Do you agree?
Not fully. The portfolio committees are multi-party bodies. Would a member of Party A, without proof, take that matter into the committee and investigate and ultimately find out that in fact there is nothing? And is such a member, especially if they are not senior enough in the party, not risking alienating? And that is precisely, if you go back to the submission centers around the inability of what is right for me to take a stand on and what might be interpreted as being not doing well by the party. And so a party member of any party, by the way, will sometimes want to have at least substance before they open their mouth. That is quite natural. And that is why we are saying in Parliament, you need to increase capacity for this private member. This member must be able to investigate properly, must be able to analyze, and be able to say, no, I'm sure there is a case here. And I'm saying alternatively, with all these powers that vest in the committee, this member might actually decide, hey, I'm taking it further. Portfolio committee, do you have appetite? They don't. Okay, in my capacity as a public representative, I can approach the authorities, investigate this thing further because it makes me uneasy. So for me, that would be that. I am in no way wanting to suggest that a citizen, a public representative sworn under the Constitution and to obey all law has the right to suppress information. That I would not agree with. But I want to look at how you transport things that happen out there into the committee.
I see we are at 12 minutes past 1.
Chair, I am not quite done with this witness. My suggestion is we take the lunch adjournment. I won't be a great deal of time after the lunch adjournment. Okay,
let's take the lunch adjournment and we'll resume at 2:15. We adjourn.